The menace of congestion in various categories of prisons in the country today has become very worrisome. Statistics reveal that the recent prison reform conference held in Abuja shows that close to 45,000 inmates are languishing in various prisons in the country, while about 30,000 of this number are suspects awaiting trial. The figures already show there is a huge challenge in that area that calls for urgent national attention. One of the schools of thought has it that the frightening figures speak volume of the states of the affected prisons. Some of them say require facelift and expansion to help them serve as correctional centers. The others say the country deserves more prisons that meet global standards for the benefits of full reformation of inmates. This will ensure that inmates are released as reformed persons to contribute positively to societal growth and development. The responsibility of curbing the problem lies with the Nigerian Prison Service, the judiciary, and the regulators of the prisons. Issues of funding has been identified at the various fora as one of the major factors responsible for the challenges of prisons overcrowding in Nigeria. Nigeria Today shall attempt to critically examine the issue of prison congestion, the role of the Nigerian Prison Service, the judiciary, the police, and other agencies involved in criminal justice administration. I am Segun Ojelade. I'm being joined to discuss the problem of prison congestion in Nigeria by two eminent gentlemen. One of them is the Honorable Minister for Interior, Comrade Abba Moru. Honorable Minister, I welcome you to the studios of Nigeria Today.
It's my pleasure to be with you.
On his left is a legal practitioner of Fonime, Eno. He's based here in Abuja. I welcome you to the program.
Thank you very much.
Now, Honorable Minister, we gave some statistics at the start of this program. 45,000 in all the prisons, 30,000 of them are awaiting trial. Now, do you agree with these statistics, or what is the state of the Nigerian prison today?
Well, thank you very much, and let me also express my gratitude to you for bringing to focus the issue of prison congestion in Nigeria today. Let me also state that the figure that we have today as inmates of our various prisons stands at 44,395, precisely. 54,000, did I say? 54,395. Out of this number, we have about 71% awaiting trial, which is a very, very sad development. And against the backdrop of the security challenges that we're facing now, I can assure you that the number will keep increasing. And so the state of our prisons today depicts the picture of a system requesting for urgent attention in all its ramifications. This is exactly what the reform agenda of this present administration sets out to address.
Honorable Minister, let me stop you there. Let's look at the implications of this figure, especially from the legal point of view. What does it say? 54,399 inmates, 71% of them awaiting trial. Can you analyze this figure? What is the implication of this kind of figures?
The implication of this is that there's a problem with the administration of justice, because the law clearly states how long a person can be held in custody. Specifically, Section 35 of our Constitution states that within 24 hours of a person being arrested, he should be brought before a magistrate and for a court of law. Now, if that offense is not bailable, he should be brought within 1 month. If such a person is on bail, he should be brought before the judge within 3 months. So the law is there, but I think it's a problem of administration of justice, because every day in the courts, from the magistrate level up to the High Court and the Federal High Court level, there's been logistical problems, which the officials of the state use as excuses to hinder production of prisoners to court. And also, we have a problem of time frame in the administration of justice. You see cases ordinarily that should be dealt with within 2-3 months stretch for years. And so you have prisoners who outlive the sentences of the crime they've been arrested for, even if they were convicted, but yet still on awaiting trial. So there's a problem with that
Let me
figure.
allow you to go away with some of the things that you have said. We'll come back to it later, because you didn't touch the aspects of legal practitioners in administration. Well, we'll talk about it later. Honorable Minister, if we have this kind of figures, it poses some problems, like he has said. To prison administration, for instance, cost of administration, what is the implication of this on the administrators of the prison, like the federal government, like the Nigerian Prison Service, like officers? What does it impose on every one of you involved?
A huge challenge, because as he has indicated, the dilemma of the prison system and the Nigerian Prison Service is that we are obliged to take people into custody. We don't have the instrument to release them, even under very challenging conditions. And so, the number of warders that we have to attend to prisoners are stretched. The facilities that we have to take care of prisoners are stretched. And to crown it all, the proposal for feeding of inmates will also be overstretched, because every day that we admit new persons, the feeding arrangement of inmates continues to pose a very serious challenge, because we don't also have the capacity to every day adjust the feeding cost of the prisoners. And so, from whatever angle that we are looking at it, the prison system is certainly overstretched. Again, like I said, part of the reform agenda of the present administration is to address some of these issues. For instance, addressing the issue of incapacity of the present level of personnel in the prisons to attend to the number of prisoners that we have, especially awaiting trial inmates. And because of their fundamental rights, there is a limit to which you also can attempt to even reform the system, because until somebody is convicted, he is presumed innocent. And therefore, if he has not been found guilty of an offense, you cannot even purge him of an offense. And so we have a lot of challenges addressing the issue. But like I said, it is a problem that we ordinarily have to address, and there is no running away from it.
Now, lawyer, if I can call you that. Now, are we breaking any convention, any protocol, by having so many people awaiting trial in our prisons? Are we breaching any protocol? And should we be worried, apart from breaching protocol? Is there any implication on security, for instance, or even the situation in the prisons?
Oh, yes. Like the Honorable Minister has said, every individual has, so long as you're not yet convicted, you're entitled to certain rights and certain privileges. But in the case of someone who is in prison or who has been is held under detention, you have to go through, there's a presupposition that you've been accused of an offense. And so you need to go through the entire justice system to either get yourself away from, get yourself out of this offense, or get into the correctional system. So the administration of the prison service per se cannot exist in isolation. You know, prison reforms and judicial reforms have to go hand in hand for us to satisfy the international best practices in terms of individual rights of freedom, liberty, and living within the confines of the law. So to that extent, we are not bridging any protocol so long as the person is actually going through the legal process. The only problem is the amount of time it takes for an individual to get through either to be convicted or to be discharged and acquitted. That is the challenge right now. And the Honorable Minister has said that this is part of the reform agenda, but I want to believe that the prison systems reform cannot stand alone. It has to. It's a symbiotic relationship.
Justice administration again. Maybe there is one aspect you forgot. Yes. The aspect of legal practitioners too. We have the police not bringing accused to court on as I went due, and then we have the lawyers to keep asking for adjournments, not prepared for their briefs and the rest of it. I don't think the lawyers should, the bench should, I mean the bar too should be exonerated.
No, I'm not saying that the bar is exonerated in this issue. We have lawyers who dwell on technicalities or those who come to court ill-prepared. But the value of our justice system is that a lawyer cannot manipulate the system in isolation. You cannot make a frivolous application before a judge and he will grant you that application. I think the challenge is more or less in producing the individual in court and the rules of practice which every lawyer has to follow and to be amended in such a way that it will expedite the process of criminal justice administration.
Okay.
Yes.
Now, the program is Nigeria Today. We're discussing the problem of decongesting the nation's prisons. We'll take a short break now. My two guests, the Honorable Minister and the lawyer, are still in the house. You're welcome back. The program is Nigeria Today. We're talking prison decongestion in Nigeria. The Honorable Minister of Interior, Comrade Abba Moro, is still in the house, and the legal practitioner of Fonime, Ono. Now, Honorable Minister, is there any part of the prison reform agenda of the federal government that talks about synergy with the judiciary, for instance, and the police to ensure that we reduce this number, this 71% of those awaiting trial, because there is no amount of expansion you do in prisons, even facilities and all. If this number does not reduce, maybe it can just be a drop in the ocean.
The necessity for networking and creating desirable synergy between various stakeholders in our prison system is a major plank of the reform agenda. And since I assumed duty as the Minister of Interior, we have had reason to crisscross the country, networking with state chief judges and the Ministry of Justice of the federal government in devising means of decongesting, not just decongesting our prisons, but ensuring that the prison system serves the purpose for which it is intended, primarily to serve as correction and rehabilitation and reintegration of the offender. So this is what we have done, and to further actualize this desire, there is an interministerial committee that is in place that has been charged with the responsibility of reducing the reform agenda to an implementable framework within the shortest possible time. Because given the background of our security challenge now, it becomes more compelling that a system must be in place in such a way that will quickly dispense justice. And so a major requirement of that committee in relation to the reform agenda is finding non-custodial alternative in our prison system.
What
In
do you
other
mean by that,
words,
Honorable Minister?
can we find a way of not necessarily incarcerating somebody who has infracted on the law?
Okay.
That is, can we go back to the basics and find a way of saying, you community leader, this your subject has infracted on the law to this extent, to that extent. In the circumstances, if we don't have to put him in custody, can you take charge of him and purge him of his iniquities, so to say, so that he can properly fit into the society? Or can we find alternative level of making somebody correct his attitudes? Can we find community punishment, community service as a way out of putting the person in custody? Because the implication of long and overdue stay in our prison, especially given the limited spaces that we have, is that somebody might get into the prison and come out worse than he was even before he got into the
Honorable
prison.
Minister,
Because the tendency is for them to begin to learn some little tricks in the prison system. Of course, because of the level of the performance of the judicial system, there is a limit to which you can create distance between an offender and his area of court jurisdiction where he has to attend the court.
And now, Honorable Minister, that brings me to the question of our prisons being for correction, rehabilitation, and reintegration. Even with these worrisome figures that we have, do we still have space in our prisons to ensure that, well, it may not be up to date, it may not be adequate, but we're still doing some of these things? What are those things on ground to still ensure that, okay, we still reform in our prisons?
For our prison system, I can assure you that every effort is being made to ensure that people are directed away from their criminal tendencies to more productive engagements, even within the prisons. Today, as I'm talking to you, we have about 232 prisons across the country. And we have about 3 booster stations that are dedicated to taking care of juveniles that have infracted on the law, that train them to fit into the society. And every moment, we keep recording successes. If you go to the Kujo prison, for instance, we have vocational and traits that are there that people learn every day. If you go to Ikoyi prison, and most of our prisons, we have arrangements for people to undergo basic trainings in education. And as I'm talking to you, only yesterday, 48 out of 102 inmates of the Ikoyi prison that sat for the GCE in 2013 were successful and have grades enough to enter the university system. As I'm talking to you, only a few months ago, an inmate in the prison graduated from the Open University with a degree, with a high level of success. And so the prison system, as we currently have, actually has provisions, and within the limit of the resources available to our prison service, for people to learn new trades and acquire new knowledge for proper reintegration. We have 3 programs, 3 R's.
Okay.
Restoration, rehabilitation, restoration, and reintegration.
Okay.
And these 3 R's are supposed to take care of the mental capacity of the individuals to acquire new skills and knowledge to be able to reintegrate into the larger society upon release.
Now, if we look at, because that would be the ultimate would be, okay, for the judicial system to be effective enough to be able to cope with this figure that we have. As a legal practitioner, what would be your proposal to ensure that we decongest our prisons by ensuring we fast track the period of administration of justice in our nation?
Perfect. It's a two-way program. One, provision of more facilities, building of more courts, provision of more logistic equipment to the police, in terms of vehicles, expansion of our courtrooms, expanding our jurisdiction, and at the same time, getting into reviews of our criminal justice system in order to encourage fast-tracking of criminal trials. Establishment of specialist courts, like maybe a terrorist court, for example, in view of what is going on in our nation today. We should have specialized court dealing with specialized offenses so that we can encourage speedy administration of justice. That, if done, would hasten the reduction of that percentage to an appreciable one.
No, but if you look at the individuals running the system, judges, policemen, lawyers, and even the accused persons themselves. Oh, not forgetting the prison officials. Probably we all at that level need reforms too.
For my profession, where I come from, there's a standard of practice, and we have a regulatory body in terms of how lawyers should behave in the practice of their duties, and there's also disciplinary measures for lawyers who falter. Same with the judiciary, same with the police force, same with the Nigerian Prison Service. Even within our laws, the Prison Act of 2004 has provided specifically the role of the prison system, one of which is what the Honorable Minister has stated. Provision of skills, sending them to schools, and reintegrating them into society. So we have our laws there. There are institutions there to take care of all these things. What we have faced right now is logistics problems. We don't have enough courts. We don't have enough manpower in terms of magistrates, judges, both at the federal and the state level. And I would also suggest that the issue of prisons administration should be taken off the exclusive legislative list, and maybe the states and the local government can take part in building of this prison, because there are states that have gone ahead to build prisons.
The Honourable Minister will be interested in commenting on that quickly because of our time.
Yeah, I think there have been suggestions in quarters as to whether we wouldn't go the way of removing the prison system from the exclusive legislative list of federal government. But again, like the clamor for the Nigerian police, we still have some level of concern when it comes to issues of our democracy, issues of our attitude to the system that we operate. And the possibility is there, given the circumstances in which we operate now, where a state government will enact laws that will lead to clamping people into prisons without any corresponding facility for accommodating those people.
So we still need to look at
so
that
we, we need to look at the nitty-gritty
yes,
of how to operate the system.
Proposal.
But what we're trying to do within the prison system now is an arrangement whereby we can involve the private sector in managing our prison system to meet with best international practices. And as I'm talking to you, there are plans underway for an understudy of the practice of private-public partnership of the prison management system in South Africa.
Now, Honourable Minister, quickly, if we bring you here, in no distant future, based on what you said, that the government is trying to prioritize those aspects of prison reforms under this transformation agenda that come like quick wins. If we bring you back here in a no distant future, what are those things that you are promising that will be in place?
Well, I assure you, for instance, that some of the facelifts and upgrades that are going on in our prisons will be completed. For instance, we just have to have enough space, no doubt about it. And of course, the arrangement that we are making with the judiciary to fast-track movement of persons from the prisons to the courts to ensure early administration of justice will be in place. And so there are a few quick wins that we expect from the committee's report that will be available in no distant future. And those ones will be implemented to ensure some quick wins in this direction and a decongestion of our prison system, which had been misdirected in the past.
Okay. I must thank you, Honourable Minister, for coming on the program and some of the issues that you have raised. We thank you most sincerely.
Thank you. It's my pleasure to be with you. Thank you.
And then, lawyer of Fonime, I also thank you most sincerely for coming on the program.
Thank you.
We wish you the very best in all that you do.
Thank you very much. Thank you.
This is Nigeria Today. This is why we call it a date. Until we come your way next week with another edition, I am Shegun Ojelade saying bye-bye.